Good morning, I'm Dylan Labotsky, Attorney and Public Relations Officer at STBB, Bloberg Branch. Today we're going to be chatting a little bit about what we'd like to call selling property subject to an existing lease agreement. Now this is an occurrence that we find ourselves dealing with on a regular basis in the conveyancing industry or in practice when dealing with transfers, because what would happen is usually when there's a property that is subject to an existing lease agreement, meaning that a tenant is currently occupying the property, but the seller has now decided to sell his property with the lease agreement still being of force and effect, meaning that it's still running and that there could be a certain amount of months left on the lease agreement as between the seller and the tenant, the seller in this instance being the landlord. So there's nothing prohibiting the seller from actually selling the property. He's more than entitled to do so. However, the question comes up as to what happens to the tenant and the existing lease agreement. Can we cancel it? Do we take further steps in removing the tenant? I'm going to tell you exactly how we're going to deal with that. So your first point of call that you need to look at is, firstly, if you're a seller and you're aware of the fact, or an estate agent for that matter, are aware of the fact that there is an existing lease agreement on the property, you need to bring this to your estate agent's attention as well as your conveyancing attorney. The reason for this being is that the conveyancing attorney will have to take the necessary steps in practice to deal with this lease agreement. We need to make it clear that in these instances, you cannot cancel an existing lease agreement when a property is sold to a purchaser. The reason for this being is that there's a common law maxim known as herein, constitute, meaning that any existing lease agreement shall endure despite there being a subsequent sale, meaning that even though the purchaser might take ownership and possession of the property on registration, the tenant and the lease agreement will still have to endure. So how do we deal with this? The best way to deal with this would be to instruct your conveyancer. Your conveyancer will already know that they need to attend to the drafting of a cession of lease agreement. A cession of lease agreement, in essence, is basically a document that transfers all the rights and obligations that the seller would have in terms of the lease agreement to that of the purchaser. In other words, the purchaser will step into the seller's shoes. And this purchaser, subsequent to registration of transfer, meaning that the property is now in the purchaser's name, will be the new landlord, meaning that any rental income that is due in terms of the lease agreement is now paid to the purchaser, and the purchaser has obligation and rights and so forth as the landlord would towards the tenant. This is done by your conveyancer, and this can be done anytime prior to registration of transfer. Another question that you might be faced with is, what if there's a managing agent busy managing the rental agreement or managing the property at that stage? Well, then we'd need to get the managing agent to sign the cession of lease agreement as well. This being important because there's a mandate and there's obviously certain rights that the estate agency or rental agent would have in terms of this lease agreement, and as such needs to be incorporated and brought into this session as well. So when in doubt with regards to whether or not there's an existing lease agreement and so forth on the property, it's best to make 100% sure with your seller. It's also good to check the lease agreement for you to provide a copy of that lease agreement to your conveyancing attorneys so that they may peruse the document accordingly and thoroughly so that nothing is missed and that the transaction runs as smoothly as possible. We also ask ourselves, and this is somewhat of a litigious matter, so we won't touch on that today, but in the event that the lease agreement registration of transfer has occurred and the purchaser is now the landlord, as discussed earlier, and the lease agreement has now expired as a result of effluxion of time, we now ask ourselves, if the tenant does not vacate the property, what steps do we take? And in that event, after the expiration or the termination of the lease agreement as a result of effluxion of time, the purchaser has the ability now in his capacity as landlord to issue a notice or to give 1 month's warning prior, which is actually your first prize, in writing to say that the lease agreement will not be renewed. Should the tenant fail to vacate on the date upon which the lease agreement expires, then the purchaser will be in a position to take further steps and ultimately, if the tenant does not vacate, approach your court for an order for eviction. So if you're ever posed with a instance whereby you're selling property and there's an existing lease agreement over the property and there's a tenant currently in the property, please talk to your conveyors, please bring this to your attention, and we will ensure that all the necessary steps are followed properly, thoroughly, to ensure that your transfer is smooth and that it is a happy process and a joyful, special process to all parties involved. Thank you for listening. For more information, please visit stbb.co.za.